quiet now? Committee of the whole, let's begin. Roll call, please.
Grossi. Here. Eustace.
Here.
Howard.
Here.
Ogella. Here. Sorry. Here.
Here.
Moran. Here. Rice. Here. Harris.
Here.
Rainier. Bible.
Here.
Freitag. Here. Bull. Dallas. Here. Frizzalone.
Here.
Winfrey. Here. Adamick. David. Wilhelmy. Hart. Here. Mayor.
Here.
McDermott.
Here.
Weigel. Collins. Terry.
Here.
And Brooks.
Here.
We do have a quorum.
All right. Pledge allegiance. Mr. Harris, please. Pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Approval of minutes. We have none. Public comment. Anybody? Public? Do we have anybody signed up? No public comment? All right. Old business. We have no old business. New business. Building ordinance review, and everyone have that draft attached. Jim, Mr. Musis, let's begin with Jim, and then Ray, I'll come to you. Jim?
Thank you, Mr. Chairman. On behalf of the ADAC committee, I want to thank everyone that was part of this process. But here's what I'd like to just let everybody know. We operated off the 26 codes, and we're looking at the 2012 code. And there seemed to be one recurring concern, and that had to do with sprinkling of residential, one and two unit residential units. There were some other issues that also the realtors were concerned, the building community was concerned about. But we did address all those concerns. And I want you to know at the last public hearing, which was Tuesday at the Planning and Zoning Commission, there was nothing but support for what you have now on your desk. And there was nothing but accolades for the system, the land use department, the building department, the ADAC committee. So I want you to know that any concerns you've heard in the past were addressed. And like I say, in the last public hearing, there was not one objection to any parts of this new code would be adopted at our next time of work. So I just want everyone to know.
Okay. Now, before I go to Ray, I do have to acknowledge any other executive board members. Any comments? Executive board. All right. Thank you, Jim. Oh, Chuck? Okay.
Yeah. I do appreciate all the work that was done on this. I know this has been a huge endeavor to go through this, and we've got a lot of feedback. There are, I do have several comments about the packet and questions that I wanted to ask. Some of them are on process and policy. And if you don't mind, I'd like to take a couple seconds to do that.
Sure.
Well, just one thing, under 150.03, at the first part where it says agriculture exemptions, you might want to look at AA where it says any plumbing or electrical wherein will require a permit versus required. Should that be a past tense?
Now, where is that? 150?
Just the first page of the draft. Page 2 of the draft.
Okay, at the top. What's the question again, sir?
No fees, see agricultural and zoning ordinance. It's an exemption. Any plumbing or electrical wherein will required a permit. I think it should be required a permit. Yeah, I know. There was relief of responsibility. I just have a question that I'd like the state's attorney. I'm going to throw out my questions first before. But does the law state, and it says there that we're not going to, that we will support them if anybody sues them, paraphrasing here, but acting in good faith and without malice. Is there anything in the state statute that talks about if they did something illegal? and whether we would support them if they did something illegal in the process? Or does that language cover that?
If the building official did something criminal, committed a
Correct.
criminal act, no, I don't think we would support them. I think we would be legally prohibited from supporting them.
And my question, I guess then, Mary, is if does this state what it needs to state for that, since we're creating a policy, or should we, at least from a policy standpoint, add something in there that reflects state statute that if that there's a crime or some illegal activity?
Well, it says in the lawful discharge of his duties. So I think that it anticipates that it will be his lawful duties. That's what the Tort Immunity Statute provides.
Okay. I just want to make sure that
Yeah.
with the way we're reading this is that that's the process. Okay. On the next page, page 3, under section B, number 2, we talk about 3 paper copies being distributed. We just all had our iPads passed out to us, and we're trying to go electronic in order to reduce paper costs and things along those lines. Is there any problem with adding an electronic copy to this? It's the application requirements, section B, paragraph 2. For construction alterations and other work, 3 copies of construction plans will be sent. And so I would like to make sure that we have a discussion on that, and I will move on because I think that we really need to have a little discussion on our adding electronics.
Before I go to you, Bob and Don, I want Mary, if she could comment on that.
That's a policy question as to whether or not you want electronic or paper version. It could be that land use needs some hard copy. They can scan it in, I would expect, and create an electronic version for.
But on the next page, they talk about returning copies to people, and including the people that are.
I was trying to find where you're at exactly.
On page 3.
Page 3, application requirement,
Number 2.
paragraph 2, number 2.
And I've got it in paragraph 2 for construction alterations and other, 3 copies,
Right.
I see, okay.
First sentence. And then half that stuff gets, and then those copies get returned to the originator, and one for land use to keep, and one for one other group. And that's why I'm saying if we could go in, and I would want to put in e-copies here. It makes it a lot less expensive for our businesses as they're doing this. It also allows.
I would let the building people comment on that, but I
Yeah.
will say that as staff, constantly looking at a computer screen can be very hard on your eyes and very difficult sometimes to discern. And these are, usually the plans can be very large, so reducing them down to a small screen can also be an issue for them.
And
But
so
I'll defer to building
Yeah, that's fine.
staff.
I don't have a problem with that aspect of having 1 copy maybe submitted, but to go in and have 3 copies of it eventually be given back to the same people, I just think that it's an undercost.
Okay.
If I might speak to that. 3 copies are not given back to the individual. What this is, my name is Ray Semplinski. I'm the Chief Building Official and Director of the Building Division and Land Use. We take 3 copies because we have a working copy. We have one that, when approved, goes back to the actual contractor to post on site, and the 3rd goes to the assessor. So those are our 3 copies. We retain 1 for records for a period of 5 years. We would like to call and say e-copies, but we don't have the software or the viewing to be able to examine them, first of all. Secondly, when we give these things to the assessor's offices, not many, if only a handful, might have the capability of storing these or taking these and filing them in their own offices. So they've asked us for the paper copy, and that we would like to go paperless. That's a great thing. But some of these things that we've done, Will County tends, even with its homes, it's not unusual to see a 6,000 to 8,000 square foot home. So you can imagine the volume and what you've got to do to review this page by page and then overlay them at the same time. So sometimes physically it's a lot easier to do that. But what we do is not return all 3 copies to them. 1 goes to the assessor, 1 goes to the contractor, and we keep 1.
No, I understand that. And so maybe rather than just make it black and white that it has to be paper, maybe upon agreement, depending on the project?
We could say and or, absolutely. Many of the commercial developments we have do submit CDs with all the cut sheets regarding their HVAC, their plumbing schematics and such, so we can, we do take those.
If we could take a look at and or so that we would have that ability to do either one according to the agreement with, so that we're not just cutting people off and saying, I'm sorry. Yeah. There is on page 5, section G, paragraph 4. It talks about the duties and authority of the building officials, and it talks about making inspections for that purposes, and they enter building and structures and premises. Is that without notice?
The only way I can enter a structure, unless it's compromised or involved in a particular damage event, is when a permit is posted. I have no empirical rights and no way to enter a property without those criteria.
If the permit is posted, can you walk into that property at any time?
It allows me access to the property. It doesn't allow me to just walk in. It allows me to make every attempt at notification before entering.
And I guess that was my only issue, is that I didn't see anything in here that talked about notification and or time frame, that we would notify versus just walking into or being part of in someone's house.
Well, what it does is when we conduct our inspections, many times these homes or these businesses or these sheds are unoccupied, and we can just go into a backyard, we can look at a shed or look at a detached garage or a barn without making notification to the building, to the people, as they have called us for the inspection. We make them aware of what day we're inspecting and the hours we'll be out there.
So you are giving them notification of when you're coming out there, and I guess I'm just saying that the way this is so nebulous, that I didn't get that in reading here. So what you're saying is that you're making an inspection with notification or a request by...
Inspections are upon request unless it's a damage situation.
And I would just like us to be able to reflect that. I just don't think that we as a government body should have that kind of... You may be interpreting it that today, with somebody reading this could say, well, I have a notice up there, I can just walk in. And I'm not saying that that's our practice. I'm just saying that potentially...
Your practice has always been notified first, though. Is that right, Ray?
It's governed in our codes. I would ask, I know you may have been wanting a PowerPoint, or you may have expected some polished individual to present things to you. I would ask for my visual aids to come forward, please.
Oh, but before they do that, I have to go to the executive board first. And I have some questions by the executive board.
Well, the visual aids amount to what is actually embodied in this book.
Oh, that's right. I'm not executive yet. Okay. I'm getting mixed up.
If I might ask once again, I have two plans reviewers, both my commercial plans reviewer, Andrew Pieri, and my residential plans reviewer, O&M, bring down our visual aids.
Okay, while they're doing that, Bob Pollard and then down the ramp. While they're doing it, come on down.
I don't want to come down.
No, not you. Use your mic. Use your mic. You're on. You're on.
I think, Ray, along with that electronic filing, I don't know what the percentage is, but homeowners actually utilizing your service. And in the past, I've utilized the building department as a homeowner. And I think we should always be homeowner friendly on this. I don't think we should ever, I think an option could be maybe on the electronic form. But the problem is that we don't want to force somebody into hiring an architect or doing something just to get the electronic form. They should always be provided until technology takes over, that they can submit their plans in a simple, drawn-out fashion on a piece of paper. Because again, I'm kind of interested in what the percentages of homeowners doing additions that you actually deal with, the decks and stuff like that. So that's something that we should always be homeowner friendly, and we should be known as homeowner friendly. So.
I think the and/or clause.
Correct.
Might
Then
say
I would say so. I would agree with that.
Okay. Down the ramp.
My concern is more with commercial construction, where you could have dozens to hundreds of drawings. The cost to plot all those on these size drawings for our people to use in the field to do their inspections and stuff, that shifts a lot of the cost burden to the county, and I'm concerned about that.
Okay. Okay, right. I'm sorry, Chuck.
Mr. Meyer, still.
No, I'm good, I'll wait till next year.
Okay, okay, all right, okay, great.
Okay, thank you, Mr. Chair, and good morning, ladies and gentlemen of the Will County Board. My plans examiners have distributed this among you, and I don't propose to read this to you. Certainly, our ad hoc member, Mr. Mustis, has given you an overview. You'll see a little more of why we've done things. I mean, codes initially started out with the Chicago fire, and then with the earthquake, because they found that structures sometimes don't meet the real need of the environment. So the codes that we presented in this book are laid out in visual aids right there, because everything in here deals with that, right down to what a code official is allowed to do in entry and what they're not. We have never abused this power, nor would I seek to do that. Anyone doing that after me would not be covered with, I believe, the tort immunity, because I think that's some sort of prejudicial analysis and probably something of an environment we don't want to be within. Now, in Will County, the 850 square miles that we cover daily, we do it with 2 plans examiners that we do for residential and commercial. We do it with a total of 3.5 inspectors, 1.5 plumbing inspectors and 2 building inspectors. And we do the inspections the very next day. They get done. No matter what it takes, they get done. So that we've been ahead of schedule, and we've done other things such as taking in the village of Diamond. They are now ours to do with our extended service resolution that was passed by the board some years ago. They put their faith in us to take care of the 224 homes that were damaged, to take care of the businesses that were destroyed, because they know that we can do this, and we can do it at a level that is going to reduce their ISO rating, which you'll see why we changed the codes. It's to stay current. It's to stay up with all of the technology and all of the new materials that come out daily. You know, before, when I started, we talked about phone booths. Now we talk about cell towers. Things change. I've gotten much older. But we do this with I-joists. They're made out of, instead of a solid piece of 2x12, now you've got a piece of what looks to be flake board sandwiched in with a couple pieces of wood top and bottom. And the firemen were saying that, you know, this gives us 17 seconds of a full pack when it's engulfed in an event before we fall through the floor. Now we have intumescent covering, which expands and allows that I-joist to perform the same way as the 2x12. So we have to look at this, and it's cost cutting for the people that work in Will County, as well as leveling the playing field. All of our builders know that they're going to have a certain grade of lumber, because that's what the specs call for. All of our builders know that these spacings have to be at a certain level, because that's what the manufacturer says, and we make sure that they do that. So that's why we have codes, and when we change every 6 years, it allows that 6 years where the contractors are allowed, without having changes every other week that affect their bottom line, to construct the buildings and be aware of what's coming. Now, we had talked about so many things that were our codes, but we have state mandated codes too. The accessibility code is state mandated. That's a law. The energy code is now a law. Radon is a law. We have no interpretive or any kind of way of saying, no, you don't have to do that. We have to follow that. What we've accomplished in the past 14 months, I know sometimes it seemed like we were spinning our wheels, but this is the first time that this building ordinance has ever been put before the county for involvement, have ever had the transparency that we've had, posting every change on our website, bringing in people from all walks of life as our ad hoc committee and input to give us things that we hadn't thought about. As a result of this, you can go on the Will County website now, go to the building division from Will County Land Use, and you can actually click on any one of the codes that we are showing you for all those pages on that site and have each and every page in front of you at no cost. That was brought about by the ad hoc committee. That was something they said, why can't we? Well, we talked to the ICC, and at first they were a little bit reticent because they sell these things, but they gave us a read-only, and without this ad hoc committee, that wouldn't be available. We had another thing. Embedded in all of these books is an appeals board. The appeals board is in that language, and heretofore it was omitted. There was no appeal. And as I told so many people so many times, I am not infallible. As your final decision maker, sometimes I stay awake late at night wondering if I've done something correctly. At least this is a way that someone else can weigh in and tell me whether I have or haven't. So this is another thing that is going to be in this particular one. We also went through the green code, which I'll be coming up very, very shortly with, for inclusion in our building ordinance as a voluntary measure, which everyone is still in favor of, but it gives us a measure of grading these people, being able to review this so that the proper measures for construction are met. We've had a lot of hours that we've put in. We've had a lot of great input. We've had day sessions, night sessions, and through it all, it's all been in front of the public eye from day one. So my hats off to my ad hoc committee. I couldn't be happier or prouder of them. They may not know what the span chart is and how long this 2x6 is going to stretch. But what they do know is that this affects people, and to take the input that they get and be able to generate the questions to us needed for us to frame this document to make sure in the years going forward, that's the best thing, most tailored for the County of Will, our building, and the way we want things to appear construction-wise within our community, within our county, so that we will continue to have our ISO 4, if not a higher rating, so that we can continue to deliver to the underwriters the fact that we are a very certificated, highly trained group, that we enforce the current codes and we're staying current with all of our continued education, that we continue to do that so that they can realize, well, reductions in their homeowners insurance across the county just by the way we conduct our business and building. Okay. I don't think I have anything more. I would give it to
Maybe Bob Howell's hand up first and then Judy.
Just for clarification purposes, the only thing that never changes is things change consistently. So that any point in time, there's a new development in the construction industry or whatever, we can always amend this in the future. This isn't the end all what we're passing here. And by no means is it going to be closed for the next 10 years or 20 years. It could be opened up again.
This is a living, breathing instrument.
Correct. So everybody should understand, and just, I want to hear it out loud again, is that basically we can amend this in the future by a simple act of the board, correct?
Absolutely.
Okay, thank you.
You gotta say it. You gotta say it out loud.
Can I say it out loud?
Yes, sir. You may.
Jim and then Steve Ballant.
Yeah, I want to talk about some of Mr. Mayor's comments. I know you're going to truck. I was thinking I was going to play a trucker, Mayor. But Mr. Mayor's comments. The committee really focused on the technical part of the ordinance. In other words, the actual building codes themselves. Some of these general provisions, application provisions, we didn't really focus on that, but I will tell you that some of the stakeholders did. And they did give comment on the provisions, especially about the application form and process, which they were also satisfied. When it comes to some of these other provisions, we didn't really address any of this. And at no point did, and there was a significant representation from the building community, both commercial and home builders, and they never talked about electronic filing and so forth. I think they were probably, many of them probably don't have the ability to do it. But either or, I think is okay. I mean, you may do it electronically, but
we leave the door open.
yeah, or dual. But some of those other provisions, I think, are probably something the state's attorney's office could look, perhaps just review. So some of those early, they really deal with more with the application and general operating kind of provisions, or how the process will go. I think we're on pretty solid ground. I just want everybody to know that at no time did it really become an issue. And there were stakeholders who did review it and made comments towards the end on some of those issues. Just so you know that it seems to be an issue. Harry, I think you should always give a review anytime
Mayor Guzman was at all of these meetings
Yes, he
and
was.
hearings, and I think that he reviewed this as it was being drafted, so.
Okay. Okay.
Yeah, not that I don't think Mr. Mayor's comments are valid. I do. I just want you to know that wasn't our focus, and we really kind of rely probably more on the State Attorney's Office.
Okay.
And quite frankly, myself, rereading it, I didn't see anything that jumped out at me that said, well, we need to change this. Right? We need to come up. In our ordinance, building ordinances, and the reason you adopt new codes is because things change.
Right.
New materials are used, different techniques are used, different engineering philosophies may come into play. And that's one of the reasons we change it, so we can keep up with modern materials and building techniques. So the whole, that would hold true for the whole ordinance. Sometimes you just need to update it. So, but I think we try to do that.
Oh, okay. Steve?
Yeah, I was on the committee, and I support the end result, and I'll be voting for it. But we did not address any of the issues concerning existing properties in a thorough manner. So there's things in this 2012 code that, it's too hard for me to agree to it and say, this is great. But the, like you have to have a fence and a permit for a 2-foot high pool. There's some things in there that I don't like. I don't like the energy code. And then my question was, if we don't enforce federal law, why do we enforce state law? There's a lot of ambiguity in a lot of this. But the end result of what our committee did was fine. I'm going to be voting for it. But I do have a question why the statute of limitations wasn't put in here, and I couldn't find it in the code. Because the federal law, there's a statute, section 3282 of Title 18 United States Code. It puts a 5-year statute of limitations on anything that's a non-capital offense from the time the offense was committed. And I'm just asking why that wasn't included in this code. The state of Illinois has an 18-month statute of limitations for misdemeanors. And when you read this United States Code, it goes into codes, it starts talking about terrorism and it goes on and on. But it's like a building code violation is nowhere near this stuff. It says 8 years for an assault on a diplomat. After that, no, it's too late.
And
I want to know why we haven't included the statute of limitations.
Okay, I'm going to Ray, and then I want to see if Mary want to comment, and then our chairman, Tom Weigel, should as well.
I think my first response would be, we don't consider our constituency, our owners, our residents, offenders. We are the built community. We are the ones that initially watched the building come together, watch the structure be placed together. The building codes deal with how we're going to construct these structures, not how long they've been standing, not whether we're considering them an offender. All it is putting the building together. Now, we do have an existing building code in the IRC and IBC, which states that if it was placed and was built according to code at the time of installation, it remains, unless you open it up and begin to change it. So we don't go back on anything that was constructed years ago, or even in this case, if we went back to last year, if this building ordinance is adopted, if that was built to that code, it stays that way.
I'm going by federal law, and if we're going to follow the pattern here, state law says we have to adopt the energy code, and then there's certain things in state law that our county board ignores, and other county boards ignore. For instance, the immigration law, we have Sanctuary City in Chicago, and that's against federal law. We're talking about marijuana dispensaries and grow houses, and that's against federal law. So we pick and choose what we want. But now I'm finding that there's a statute of limitations that is a law, and we're saying that there is no statute of limitations because you don't consider them an offender, yet they get a violation notice and they have to go to court. And I know that there's been cases, not too many, where people actually lost their property in the court fight. So, you know, let's be honest about it and say, all right, maybe we have to address that issue. We abide by the federal law of 5 years from the date that the offense was committed. So if a person put a shed up 10 years ago, that's null and void. Just like if you robbed the bank 10 years ago, you would not go to jail anymore because I couldn't try you.
See,
Couldn't be prosecuted.
Ray, rather than comment on that, our chairperson, Tom Weigel, had his hand up first.
The Land Use Committee is reviewing the statute of limitations, and Mr. Izzo has brought this up before our committee for non-conforming land uses, and we are considering that. It was at our last meeting, and it will be at our meeting next week. So that is something that is on our agenda. But as far as this building code is concerned, I think it's ready to go, and I'd like to thank all the stakeholders that helped us through this process, the realtors, the home builders, the Farm Bureau, and the Fire Chiefs Association for their input.
Thank you, Tom. John Moran, no, okay, Jim Easy.
You know, I just want to maybe address Mr. Bowdge's, some of his concerns there. You know, there's a difference. People have not committed a crime here. They have a structure that is either non-conforming, it doesn't go up to code. There should not be, there's not a limitation, there's not a statute of limitations on bringing something up to code. If you did it without permit and it's not up to code, you should be made to bring it up to code. If you put a shed in a water, a drainage easement, and you're flooding people down the road because you weren't caught, doesn't mean you can continue to be out of code or out of compliance. So there is a difference. Like I say, these aren't criminal charges; they're not even misdemeanor charges. What you're being told is you have to bring it up to code. I favor people bringing up the code. And if you put a building in the wrong place, and it has a negative effect on other property owners, they should bring it up to a standard, the county standard. So I understand what you're saying, but you can't oversimplify it and say, well, you got away with it, so now you don't have to comply with the law. You're not being charged. It's coming into compliance. That's the only way to understand that.
Right.
So there's a difference. And we're asking people generally, and I know sometimes there's fine. I'm not talking about the fine part or how they're charged. All I'm talking about how they get the evidence. I'm just telling you that people who are not up to code and have potentially negatively affect their neighbors, the surrounding area, yeah, they need to go up to code. So anyway,
Let me have Mary Tatro before I come back to the committee. Mary takes a comment, and then Bob Howard, you'll follow Mary.
Can I ask the question though to Mary? Because I'd like to, maybe she could sum it all up.
Okay.
Real quick.
Okay.
Yeah, basically, Mary, prior to them going to court, does Mr. Balik's statement pertain to this? And after they go to court, once they're in a court of law, does this pertain to this?
The federal statute of limitations would not be applicable to a local ordinance. Does that answer your question?
State also. He said the state has a law on the books.
Well, their statute of limitations also would not necessarily apply to this. And for a variety of reasons. It's much more complex, so I'm just going to give you the simple answer. It wouldn't apply. But you also need to realize that ordinance violations are ongoing violations. So every day it exists, it's a new violation. So even if you have a statute of limitations that says you can't charge something that happened 5 years ago, it's in violation today. So if you have a house that was not built to code, that house is still not in compliance with code today and is in still violation. So the statute of limitations would not stop the charge. It may stop how far back the fines go. And there's very good reason for that. If you use the example that Mr. Semplinski did of the building material that's particle board essentially glued together, and a house was built with that in violation of the code, you can't say 4 years later, gee, I just got caught, so I shouldn't have to fix that. some firemen should come in and die because of it? I don't think that's what you want. I don't think anybody on this board wants. But that would be the consequence if you had a statute of limitation crafted in such a way that the violation would cease to exist after 5 years, even though it wasn't built to code. There are very serious life safety issues that are addressed, and people need to bring it into compliance, whether it's a wiring issue, whether it's they don't have the proper railing for a stairway, whether it's windows weren't properly installed and someone could fall out of a second story. There are a lot of issues. They need to be addressed. These are ongoing violations. So that's one of the reasons why you wouldn't have a very simple, statement of statute of limitations.
Okay. Thank you, Mary. Chuck?
And Mary, I think that was a really nice explanation here on helping lay that out, because this is a complex issue. And maybe the word statute of limitations might not be an appropriate terminology to take a look at setting, like for instance, if that same house that was built with that particle board was built, and at that time that it was built, the code was in fact okay with that.
That's already addressed.
And that's addressed, right? So it's not like if the time your house or that construction was done, the code was taken care of. It's if you did something out of code during the time frame that it was
So
there.
if it was built and it was in violation of the code in place at the time you built it, then it's an ongoing violation. But if it was in compliance with the code, then it's a legal non-conforming, or it's just grandfathered in, depending on the situation.
Okay. All right.
Non-conforming is still an ongoing, even non-conforming uses are also an ongoing violation of the ordinance also.
Well, no, not really. No, they're legal non-conforming, and that usually is a situation that should they make significant changes, they would in fact have to bring the property into compliance. But it's not a violation of the ordinance because the ordinance specifically deals with that such that they are in compliance. They're just legal non-conforming.
Have we defined that, Mary?
Yes.
Those numbers?
Yes.
What the percentage of the change in the house has to be in order to have to do
I
the whole
believe so.
upgrade?
That's my recollection. I just want to see the legal.
There are two things in the code that can weigh in on this. In the NEC, it says if you have more than 50% of your home either damaged or reconstructed, then all of the wiring must change. All of it has to be brought up to code. In the building section, existing building states that if you don't open it, you don't fix it, as long as it was compliant at time of installation. So that covers that. There's no real percentage in the building portion of it. We also have a clause for historic buildings, so that we can take limits there. Basically, in Will County, some of the old farmhouses that have Navitube wiring, if they don't touch it, it stays.
Okay. All right. Bob Howard.
So along that lines, Mary, being a member of the Land Use Committee, technically we shouldn't even address that statute of limitations because we have no authority to touch that, correct?
No, I wouldn't say you don't have authority. I mean, you can address those issues. From a policy standpoint, you could be going down a very dangerous road depending on the manner in which you choose to do it. I mean, there could be some common sense ways where maybe if somebody built something 20 years ago, you may not want to fine them for 20 years worth of fines. You may want to say, listen, you need to bring it in compliance, but we're only going to charge you with fines going back a year or 5 years or whatever the committee would decide. We'll say by and large, certainly when we were dealing with ordinance violations, the courts took care of this. No judge was going to impose, generally speaking, a tremendous fine on someone. We had a few isolated incidents where we had egregious situations and people were refusing to bring them into compliance where we did have some very large fines imposed. But by and large, if the people brought them into compliance, there wasn't even a fine imposed. We were looking for compliance.
All right. Okay. Thank you. Mike Frislow.
I just wanted to mention on the electronic, Ray, if you need a set of paper to do your inspections, you shouldn't do just a total either or. It's like Mr. Moran said, we'll wind up printing out eons of paper at our cost. So it should be maybe at least one paper, and either or 2 more paper and CAD drawings as well.
All right.
So we're not on the hook.
Okay, all right. All right, Ray, we want to wrap it up. Any final?
The only final comments I had was a thanks to all that stayed this long here and to listen to this, and for the first time to say thank you, because we've put ourselves before you, given you some opportunity to say what you wish to say, and hopefully we'll come away knowing that whatever we do is going to be the best we can to make Will County better, to make it safer, and to continue our services very timely. And hopefully, when you think about that bad guy that's been inspecting your house and failed you, you'll know that there's actually reasons why.
Okay.
Thank you.
Thank you, Ray. Thank you to Chairman Tom Weigel, the ad hoc committee, Don Moran, Jim Eustace, Steve Ballard, and Bob Howard, and all of you that attended those meetings to make this happen. Thank you. Tom already mentioned all the stakeholders, and so we want to thank them all. Don?
I'd like to make a motion to move this to the full board with the recommendation to approve.
Moved by Don Moran, second by Chuck Mayer. All in favor?
Aye.
No? The ayes have it. Thank you so much. And thank you to all the land use for all the work that they've done as well, your staff. Thank you, Ray. All right.
Are we going to continue the executive committee here?
Yes, right here, right here, right here. No other new business. No announcements. Do we have executive session, Mary? Thank you so much. Motion to adjourn. Second. All in favor?
Aye.
Thank you.